welcome back to another episode at Divorce at Altitude. I have the pleasure of having Georgina Melbye, one of my law partners, on today. How are you doing, Georgina?
I'm good, Amy. How are you?
Good. Thanks for coming on today to talk about contempt. I really appreciate it.
Of course.
So give me a little bit of background about you. Obviously you do family law, criminal defense. What else is interesting about you?
Sure. Well, Amy, as you know, I moved up to the mountains coming up on about 7 years ago to start working with Ryan, and I fell in love with the practice of family law and criminal defense, and really enjoyed, obviously, the firm growing to include you and a bunch of new associates. Outside of the office, I like to do, general mountain activities, biking, skiing, hiking, hang out with my dogs.
Awesome. That's great. So you work primarily out of our Aspen office, right?
Yep.
And we, or at least I, consider you kind of the guru on contempt in the firm. Why don't we just start with the basics? Can you explain what exactly is contempt and how it relates to a family law matter?
For sure. So contempt is governed by CRCP 107. There are two types of contempt. There's direct contempt, there's indirect contempt. In family law, we deal most commonly with indirect contempt. Direct contempt is if you're in live court and the judge asks you to do something and you refuse, the judge can immediately hold you in contempt. And we see that on TV. It's very exciting. Someone gets dragged out of the courtroom, thrown in jail. That doesn't really happen in our practice too often, fortunately. So most of the time we're dealing with indirect contempt, which is in CRCP 107, Section 3, and that's contempt that occurs outside of the hearing of the judge. And so within indirect contempt, we have remedial contempt and punitive contempt.
Okay, so that's kind of the lay of the land from like the 20,000 foot level, kind of getting down to the basics for just someone that doesn't even know what contempt is. Like, what is the, I guess, basic definition of what contempt is?
Yeah, so like I kind of was talking about, indirect contempt is often what we're dealing with. And that's in family law going to be most frequently at its very core a violation of a court order.
Okay, yeah. So at its basic, when someone is looking at enforcing a court order, one of the ways they could do that is through filing a contempt action. Is that correct?
Yes, absolutely.
Okay, and then just since we deal mostly with indirect contempt issues, like what are some of the common things that you see dealing with indirect contempt?
A lot of the times when we're looking at indirect contempt, it's going to be an obligation placed on a party under a separation agreement or a parenting plan that they then don't fulfill. So that's sort of the most common types of contempt that we're looking at as far as in family law. And those are mainly going to be post decree because obviously there needs to be an underlying order to have contempt. That's not to say, a party couldn't be in contempt of a temporary order or something along those lines. But we most often see it in the post-decree world. A common one that I deal with, for example, is, oftentimes there's a marital home that we're dividing. One party gets a year to refinance and, pay an equalization payment or buy out the other party from the interest in the home. Well, sometimes issues can come up in the refinance process, or sometimes someone can drag their feet. So a year rolls around and they haven't refinanced. Of course, the other party is attached to that debt when they don't want to be. So that's sort of a common one that I see in the post-decree world. But really, any type of violation of the separation agreement or parenting plan could be a basis for a contempt action.
And then just in your, I guess, practice, have you found that contempt can be like effective if someone files for contempt?
Absolutely. Where I typically see contempt being less effective, I guess let me start there, is and violations on a parenting plan. And the reason for that is because typically when you're filing for contempt in a parenting plan, the violation has already occurred. So for example, dad was supposed to return child on Sunday and dad returned child on Wednesday in violation of the parenting plan. Well, the court can't go back in time and remedy the late exchange. So the only thing the court can do, and we'll get into this more, is impose some kind of punitive sanction against dad, like a fine or jail, as a remedy to the contempt action. And so that tends to not be very effective because courts don't really like to impose those types of penalties. But also, when we're looking at parenting plans and contempt, usually what we're going to think about is, do we want to file contempt or do we just want to modify the order, because parenting plans are modifiable. And so they can be more effective when dealing with separation agreements, because separation agreements typically aren't modifiable except for as relates to orders surrounding, for example, maintenance. But separation agreements typically have, pay X amount or take this action by said date. And then if the other party doesn't abide by that, then, contempt can be a good way, in my view, to force the issue and force a resolution to the issue. And so oftentimes we'll file contempt and see cases resolved because the other party then realizes that, kind of we're coming to a point where they're going to either need to comply or we're going to have to figure something else out. So typically when I'm dealing with contempt, I would say it's most often as relating to obligations as set out in a separation agreement versus a parenting plan. And I have seen it be very effective. And that's not to say you couldn't file as well contempt on a parenting plan, because sometimes it's what's needed to sort of get the other party's attention and know that your threats are founded and there could be consequences.
Yeah, that you're serious about enforcing the court order. Some people just need that, as you and I probably have seen. Before we kind of dive more into, I know we're here to talk about contempt, but when you're talking about enforcing orders in a parenting plan, can you talk a little bit about what is another avenue to enforce a parenting plan?
Sure. Typically, and for example, in our parenting plans, we're going to have language regarding, dispute resolution contained within the parenting plan itself. So our parenting plan and many other parenting plans will have a provision that forces the party to mediate prior to seeking any court action. Usually there's an exception, or sometimes there's an exception for contempt actions, but that mediation provision, I think, is helpful for the parties to consider rather than immediately going, for example, to contempt. So that's one way that we can kind of resolve parenting issues. And then the other is, like I mentioned, just seeking a modification, because if there's constant violation of the parenting plan, it may be that plan just no longer works for the parties and it needs to be modified rather than, a party being held in contempt.
What about one thing I always look at is the statute for, I think it's called enforcing parenting time, like 1410 129.5. Sometimes I find that also effective. Like I'll file under that because the court has to rule with that in like a certain amount of days, I think, and the court can actually order additional orders to clarify something. So
that's a great point. And sometimes we do that too with separation agreements where we purposely don't file contempt, but actually just file a motion to enforce the agreement so it doesn't trigger contempt. And there can be obviously strategy reasons why you'd want to do one versus the other, but that's a very good point. There are statutory provisions surrounding enforcement of parenting plans too.
So you talked about, provisions in a parenting plan and like the alternative dispute resolution, which would mean a lot of times people have to mediate before they file something with the court. Do you have to mediate before you file for contempt if you're trying to enforce an agreement or if you're trying to enforce an order in a separation agreement, or how would you approach that?
Well, typically contempt is excluded And so you can file contempt at any time, and that is because it can often be time sensitive. So unless the parties have agreed otherwise, you don't necessarily need to mediate prior to filing contempt, just because of the types of facts and circumstances that typically make up contempt actions. That said, it can often be a good idea to try to mediate a dispute, but in many circumstances, time may be of the essence. So that could be a reason you want to just file, or other types of resolution is not going to be successful.
And would you say that there's a general timeline for once you file for contempt, how things go, or is it just very specific depending on the judge that you're in front of?
So there is a specific timeline as relates to contempt, in that you have to have the contempt served on the other party 21 days prior to the hearing on advisement. So basically what happens when you file for contempt is you file a verified motion for contempt, and so long as the court sees in your motion that there's enough there to sustain essentially a prima facie case for contempt, then the court will issue a citation to show cause. And then the court will set a hearing on the advisement for the contempt. And that's typically going to be set out, more than 21 days, because you're going to need to have that advance time to serve the other party. If you cannot serve the other party at least 21 days prior to that hearing on the advisement for contempt, then you're going to have to reset that hearing until you can get the party served. And that's so that obviously the other party has adequate advance notice of the contempt action and can be advised properly.
Okay. And then once an advisement happens, or say that you can't serve a party, what is the option, for moving forward to setting it for hearing?
Yeah, so if you can't serve the other party, then the remedies to you would be like in any other kind of civil case where you're trying to serve another party. You can ask essentially for special allowance to serve through other methods like publication. You can provide evidence, other types of evidence that the party has notice of the action, but you do need to have them personally served, or they can waive service. That's something that, depending on the circumstances, oftentimes if the other side is represented, out of courtesy, we will ask if they want to waive service, because that can obviously, personal service can be disruptive to someone's home or work. So for service, essentially it works the same way as in any other civil matter, filing the petition for the divorce. It works the same.
So Georgina, what happens at a contempt advisement? Like, what goes on at a contempt advisement?
Yeah, that's a good question. So typically at a contempt advisement, the court's main goal is really to advise a person as relates to punitive contempt. Because punitive contempt is essentially like a criminal action, you have certain rights that then attach with punitive contempt, like, the right to have an attorney, the right to remain silent, all of the standard rights that we think about in criminal work apply for punitive work, but it's a punitive contempt. But it's also a time for the judge to essentially make sure the other party has proper advisement of what's contained in the contempt motion. And at that point in time, we'll usually decide how long of a hearing we need for the contempt and then set the hearing. Judges do vary a little bit on how these are handled. Sometimes the court will just set a hearing on the contempt. And other times, most frequently in my experience, there'll be a hearing on the advisement, and then we'll use that essentially as a setting conference to set a more appropriate time, and make sure it's the correct length of hearing for the actual contempt.
And so what happens, because sometimes you'll have, and this gets kind of complicated, but you might have a motion for, or say someone loses their job, like one side might, and there's a spousal maintenance order. one side might file a motion to modify spousal maintenance, and the other side might file a contempt action because the person, the obligor is not paying the spousal maintenance. Can you explain how, when setting that hearing, are you going to set it to be consolidated to hear both of those issues at the same time? Is it going to be different, different hearings? Like, what are some of the issues if, say, in that contempt there is, a request for punitive contempt? How does that get kind of complicated with evidence?
Well, when there are cross motions like that, it does get very, very complicated. And so it really depends on who you're representing, the specific facts and why you might choose one strategy versus another. So, for example, you might be dealing with a separation agreement that contains a fee shifting, provision or a prevailing party attorney fee provision. If you don't have that in your separation agreement, you might want to file for remedial contempt, and we're going to get into attorney's fees, in a little bit. But that's kind of one consideration as relates to if there's a motion to modify and then the other party in the interim is not complying, why you may want to file for contempt, or you may want to just consolidate, because of course we also have 1410-119 that allows the court to allocate attorney's fees. So I know I'm kind of focused on the attorney's fees, but obviously that could kind of play a big role in sort of what you decide you want to do. I think certainly when the subject matter is the same, it makes sense, and most judges are going to expect that you're going to consolidate the hearing, and because obviously that's more efficient. So I think that what I most frequently see is if there's multiple motions essentially relating to the same issue, that the judge is going to be incentivized to try to consolidate those together. There is a little bit of a wrinkle that we can talk about as relates to punitive versus remedial contempt, and why that might lead, to needing to bifurcate the hearing. But most of the time, even if it's bifurcated, the judge is going to prefer to have it kind of set all on the same day, in my opinion.
Okay. Yeah, and I know that's something you and I have talked about because it gets pretty confusing when there's remedial and punitive. We might as well jump into that and talk about the differences if you want to explain, the differences between remedial and punitive.
Yeah, for sure. So the main difference is obviously that punitive carries this kind of quasi-criminal, attachment of rights to it. And so why that creates sort of this complicated situation is that you do have the right to remain silent as relates to punitive contempt. For punitive contempt, the court can essentially impose a fine or jail. Those are really the options available to the judge. The judge cannot award attorney's fees to the other side, and it cannot order a fine, for example, to be paid to the other side. The sanctions are really meant to be punitive in nature and not benefiting the other party. And so because you have the right to remain silent in a punitive contempt action, if in the motion it alleges it asks for essentially punitive sanctions and remedial sanctions, then you may bifurcate the hearing. And in my experience, usually it makes sense to have the hearing on the punitive contempt first, and then have the judge issue a decision on the punitive contempt before moving into the remedial contempt. And that's so when you have your remedial contempt action, the other side doesn't plead the fifth and not testify, because that obviously is not a very effective hearing. Of course, there is the ability of the court to take a negative inference when a party refuses to testify in a civil case based off of pleading the fifth. And so oftentimes, if it's your client that is in the alleged contempt, sometimes it may make sense just to agree to have both hearings held at the same time, because it's going to have the same subject matter, and maybe you don't really see, and you've advised your client of his or her right to remain silent. And a lot of times when I've been in that position, I just essentially had my client testify and just had the hearing all at once. But there certainly could be strategy reasons, of course, why you'd want your client to remain silent. And so in that situation, if your client is the one who's alleged to be in contempt, you might request to have a bifurcated hearing.
And can you explain to our listeners what a bifurcated hearing means?
Sure. So for example, if you set a day-long hearing for your contempt, you might have the morning portion be on punitive. And then, the judge will consider the evidence over the lunch hour, for example, and then come back with a ruling. If if the person is found in punitive contempt or is not found in punitive contempt, that essentially resolves the criminal portion. And then in the afternoon, you can proceed with the civil portion of remedial contempt. Or,
And then,
of course, it doesn't necessarily have to be the same day. That's usually how I've seen bifurcated hearings kind of work for contempt, is because the subject matter is so related, the judge likes to kind of hear it all at once. But of course, it depends on the scheduling.
so when a contempt is getting set for hearing at a contempt advisement, are you seeing judges order parties to go to mediation, even though it's not necessarily something you need to mediate prior to filing a motion for contempt?
I would say, at least in the jurisdictions that I practice in, Pitkin and Garfield County in the 9th Judicial District, I normally do not see mediation requirements being issued before contempt. So, in my experience, I don't really see that ordered. And in fact, oftentimes we don't even get a scheduling order. And so usually at the hearing on the advisement, when we set it, I like to suggest a couple deadlines, just because contempt can often be set on an expedited basis. So the typical rules as might relate to a normal civil hearing, you might be past a lot of those deadlines. So sometimes it helps to, kind of discuss those ahead of time. Of course, if you're representing the party who's potentially in contempt, you may decide, you don't want to submit anything at all, which would be, your right if punitive contempt is alleged.
Yeah, and some of those deadlines you're talking about are like exchange of exhibits or like a witness disclosure list. And what's interesting is, I've set a few contempt advisements in other jurisdictions, because we practice in a lot of different jurisdictions, and the judge set it for, a contempt hearing, consolidated hearing, but then ordered us to go, to mediation. So I think like this just comes down to, it's just so jurisdiction and judge specific, it's just, you got to know your judge and how they handle, certain things. So I think what would be helpful, like if I were a client coming into your office, just, like I've heard of this issue of contempt, like how would you explain kind of the basic elements to me, of what I have to prove under remedial versus punitive?
Yeah, so for remedial contempt, if you're bringing the contempt, you essentially have to have a prima facie case that there's an order, that the contendor has knowledge of the order, and that the contendor has the ability to comply. And so you have to essentially allege at least enough facts, to support those elements. If in your case you present enough evidence to support those elements, then the burden of proof shifts to the alleged contendor, and they have to prove that they have the inability to comply with the order. So there is a burden shifting, and it's actually discussed in pretty good detail in a case called In Re Marriage of Nussback that talks kind of about the burdens in contempt and when that burden shifts. But it's important to know that, because a lot of alleged contenders might mistakenly think that there's really no burden on them because they're not bringing the contempt action, but there is that shift. And it's typically, it's not going to be hugely challenging to present a prima facie case. Of course, by the time you're filing contempt, you definitely want to know, or you'd like to think that you can certainly prove that prima facie case Otherwise, I think you need to consider why you're filing the contempt. For punitive contempt, the burden of proof is like it is in a criminal case. And essentially, the court has to, the same elements apply, but the court essentially has to be offended by the actions of the contemptor such that punitive sanctions are appropriate. And I feel as though it's most judges, it is a pretty high standard that they consider. I don't think I've had a case where I've seen punitive contempt imposed. I think I've had some close calls. But kind of what I hear from judges in their deliberation is, well, if I'm kind of hesitating at all, that leads me to not impose punitive contempt. And another reason, not to impose punitive contempt is just kind of I think, logical one, which is if someone's not fulfilling a financial obligation, imposing a fine or putting them in jail is usually not conducive to necessarily remedying that situation. So that's, I think, part of the reason why punitive contempt can be so challenging. That said, if there's repeated willful non-compliance, then I think certainly there are cases, and like I said, I think I've had some that have been pretty darn close to getting to that punitive contempt level.
Yeah, and also I think what's interesting is if you file a motion for punitive contempt on behalf of your client when you're in the hearing, you step into the shoes of being like the prosecutor.
Exactly.
Right. So
sort of a weird position to be in.
Even as an attorney, contempt, to me gets confusing. Can you ask for jail time under a remedial sanction, or is that only under a punitive sanction?
Yeah, you actually can ask for jail in remedial contempt, but the jail has to be imposed not as a punishment, but essentially to enforce compliance with the order. So an example of that is, a party has a financial obligation. They have the money in their bank account. They refuse to pay. One option for the judge is, well, you'll sit in jail until it's paid. So the goal of the jail needs to be compliance with the order and not punishment. So that's the difference between jail and remedial and punitive.
Yeah. And I think a lot of even attorneys get that confused because they think of punitive as punishment, jail being punishment, but you can actually ask for that under remedial as well. Like you said, it's the nature of what you're asking for.
Yeah. And interestingly too, for punitive contempt, kind of on the flip side of that same coin, which is the court actually can't suspend any portion of the punitive sanction based off of compliance or non-compliance. So that's really a key difference. And, it's helpful when you think punitive, you have to think punishment. So the purpose of the sanction is punishment. You pay the fine regardless if the next day you then perform the act at issue.
Yeah, that's a really good key thing to understand the difference between punitive and remedial. So now that we've kind of gone through the types of contempt, would you say that contempt is a helpful enforcement remedy for parties in a family law dispute?
Yeah, I would say there are definitely issues that merit contempt. The way that I view contempt, though, is sort of the kind of filing of last resort. And that's not in every single situation because obviously there can be time sensitive issues. So, absent that, I think that normally you're going to try to be, especially when it comes to a parenting plan, utilizing other statutory provisions, utilizing alternative dispute resolution, potentially looking at a motion to modify before you're really thinking about contempt. And same with a separation agreement, hopefully if your separation agreement contains some sort of dispute provision, that could be useful to you. And typically judges don't like contempt. So you don't want to be, the boy who cries wolf and just constantly be filing for contempt. That really annoys judges, and they like to see parties make efforts to try to resolve issues without going obviously and filing something with the court. So, contempt, what we haven't really talked about yet is that contempt is an ex parte filing, which is pretty unique because most of the time, we need to confer prior to filing a motion. We potentially need to ask for leave from the family court facilitator, but with contempt, you don't need to do any of that. And when you file the motion for contempt, you don't even need to serve it on the other side. You file it ex parte. And so, once the citation gets issued by the judge, that's what then gets served on the other party with the motion, and that's how they find out the action is pending in most circumstances, because they won't get service of it, through ISIS, for example, when we file it. So it's pretty powerful in that respect because it doesn't require that conferral ahead of time. But because of that, if you're constantly filing contempt motions, you're going to lose credibility with your judge. So absolutely, it's an effective tool, but it shouldn't be the first tool that you utilize, in my view.
Right. So if a client walked into your office and said, he's not complying with the court order, I want to file for contempt and I want him to pay for my attorney's fees, will I get my attorney's fees back? Or how does that work with contempt?
Yeah, so I normally, you never want someone's expectations to be in any contempt action that 100% they're going to get their fees. And that, I think, is a common sort of misperception. And I actually know at least a few judges in my jurisdiction and probably judges in other jurisdictions who, if the contempt has been resolved prior to the hearing, they will not award attorney's fees at all. And essentially that's to obviously try to kind of encourage resolution, knowing that if you do, then you're not going to be responsible for the other party's fees incurred in filing the motion. And so, because of that, typically filing for contempt, isn't going to necessarily require a lot of attorney time, but it really depends, it could. So you might be filing the motion for contempt, and, depending on the money at issue, it might not be worth it to you if ultimately you're not sure you're going to get your attorney's fees paid. So if a client comes to me, typically what I like to say is we've got to be very strategic in filing contempt. And the most common times to file is if there is something time sensitive, or if there's a long history that you can present of non-compliance and attempt to work with the other party to resolve the issues prior to the contempt.
And would you say also that do you look at the separation agreement to see what it says about fees, and if you have to enforce, file something with the court that the other party has to pay? How does that, I guess, play into a contempt action and getting attorney's fees?
Yeah, so obviously with the fee provision or prevailing party fee provision, you're going to want to look at the exact language because, it could be that, if you do prevail, then you're awarded your attorney's fees under the terms of your separation agreement, and the term prevail that sometimes is going to apply only to prevailing in a court action. So that, maybe something that helps protect you, or maybe is something that makes you want to have kind of that order in your favor through court action. That being said, of course, we can never guarantee a particular outcome. So you still have to consider the overall merits of the contempt action to make sure that, it's not, for example, you're not going to potentially lose and then have to pay the other side's attorney's fees. So always we're going to be considering their underlying merit, but certainly the terms of the order that we're looking at, whether it be the separation agreement, parenting plan, or an actual order, final orders written by a judge, you're always going to be wanting to start with the language of whatever order you're looking at or whatever agreement you're looking at, and then going from there.
Since you've seen a lot of contempts, and you obviously have reviewed separation agreements with prevailing fee provisions, is there anything when you review these provisions that you think could be clear, if you're like a family law practitioner, Is there anything that would be helpful to draft in those provisions?
Yeah, one kind of interesting division that I see with prevailing party provisions is that a lot of family practitioners, and myself included, shy away from including prevailing party fees in a parenting plan. And I think that there could be obviously strategic reasons to go one way or the other, depending on your client and on the circumstances. But a lot of times parenting issues, they don't really result in a win-loss. So I think, especially when it comes to parenting plan, if you are going to have a prevailing, fee provision, you need to have some pretty clear language about what it means to prevail. And so contempt could be something that you include in that, if we prevail on a contempt action or something along those lines. So there's something concrete, because oftentimes that can get pretty murky. And the other piece of it is with the parenting plan, it can be, complicated because oftentimes parenting plans aren't followed to a T on. In almost every case, they're not followed to a T. So you also want to make sure that you're not setting up your client for failure or to award, to potentially pay the other party's attorney's fees over every little issue that may arise.
Right. Yeah, no, I agree with that. I think kind of to wrap up, I think it's important to know your judge. You practice in some probably, would you say, smaller, like mountain jurisdictions. So the way that maybe, the judges up there handle it are going to be different than the judges, I'm in the metro area, are going to handle it. Like for instance, Douglas County, like you might not get a hearing for a long time, so just knowing your judge, and whether or not that remedy is really going to be helpful if you're having to wait a long time. Is there anything within the rule that actually says that, contempts need to be set on an expedited basis, or is it just dependent on the court's docket and when they can set you?
Yeah, it is as far as I know, there's obviously the strict timeline that relates to service prior to the hearing on advisement. But other than that, you're going to be really sort of at the mercy of the court's schedule. That being said, I mean, there's obviously other statutory provisions that relate to parenting disputes. So that might be something worth considering if you're thinking about filing contempt as relates to a parenting dispute. You might want to consider, a different type of motion, like a motion to restrict or something along those lines, that's going to trigger a faster timeline. But there is, obviously argument to be made that anything that relates to children should take priority on the court's schedule.
Yeah, and I think just to kind of wrap up, at least my practice has been, like I take contempt very seriously and I only file it when it's kind of not last resort, but I've tried everything else. Would you agree with that, Georgina? Like that you kind of need to look at other remedies before filing it because it's annoying to most judges.
Absolutely. And sort of like my example with the parenting plan, contempt really is not very effective when the contempt has already occurred, because then the only thing you can ask for is punitive contempt. And so usually what I like to consider is, okay, well, we can't go back and change time, but what's needed to change this behavior moving forward? Sometimes the answer to that is contempt, but most often there's sort of a bigger framework of issues that are occurring that aren't really going to be addressed by the contempt. So that's, really where I like to look first. And then as far as kind of the most effective times to file contempt, that's going to be when there's an obligation that hasn't been fulfilled. Because that's when you can really be effective in requesting remedial contempt. I do really think that courts are inclined to award attorneys fees if they rule in your favor as relates to remedial contempt. So, that's kind of where I see contempt being most effective, but obviously it depends on your case and your parties.
Yeah, so it's definitely a tool that we have and should be considered. And I like the fact that you kind of say, like, when it's an obligation that hasn't been fulfilled, that should have been fulfilled, that that can actually be a tool to get it fulfilled, and to have someone comply with the court order. So is there anything else as we wrap up that you think would be important to our listeners or even other family law practitioners, when you're looking at contempt that we haven't covered?
Well, just one kind of point, and maybe this, for some of our listeners who maybe don't have counsel and are dealing with contempt, I think it is important to know, like you said, Amy, that it is serious. It's not something to ignore. And the reason I point that out is because if you are served with a contempt action, it's really important that you deal with it. Potentially consider hiring an attorney, because if you don't show up at that hearing on advisement, a warrant could go out for your arrest. So a lot of people think maybe that this isn't something that's serious or that has no merit if they're getting it from the other side or there's some explanation. But you've got to make sure you appear at that initial hearing. Otherwise, a warrant could go out. You might have no notice of that, and then you find yourself getting arrested. So these are very serious actions. They should be treated seriously, and you should strongly consider talking to a lawyer if you do get served with one.
Yeah, no, that's great. And then for all of our listeners, Georgina, if you could tell them how can they reach you if they have a contempt issue that comes up or just have a question. What would be the best way for them to reach you?
Yeah, absolutely. I mean, there's a couple ways to reach me. You can go to our website for Kalamaya Goscha, and you can go to my page, and that has my contact information. My email is georgina@kalamaya.law, and my phone number is 970-315-2092. I'm always happy to answer potential questions about contempt.
Well, this was great. Thank you for talking about contempt. I've consulted with you because it can be confusing and it's really, really helpful. So thank you for providing such good content, for our listeners. So we appreciate your time. Thank you for listening to another episode at Divorce at Altitude, and have a good day. Thanks.